Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shivsena was chaired by Mr. Uddhav Thackeray in his capacity as the Shivsena president, party president, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the president of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the legislative party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena. The Speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the Speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the Speaker must only recognize the whip appointed by the political party. The decision of the Speaker recognizing Mr. Gogaole as the chief whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the Election Commission of India. This is because an order of the Speaker attains finality only after all avenues for appeal have been exhausted or are barred by the passage of time. The time that it would take for an order of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutionally entrenched institution which is entrusted with the function of superintendence of and control over the electoral process. The ECI, which is a constitutional authority, cannot be prevented from performing its constitutional duties for an indefinite period of time. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. In arriving at this decision, it is not necessary for the ECI to rely on the test of majority in the legislature alone. In cases such as the present one, it would be futile to assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests in order to reach a conclusion under paragraph 15 of the Symbols Order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case, and having dealt with the judgment, we say the disqualification proceedings before the Speaker cannot be stayed in anticipation of the decision of the ECI. In cases where a petition under paragraph 15 of the Symbols Order is filed after the alleged commission of prohibitory conduct, the decision of the ECI cannot be relied upon by the Speaker for adjudicating disqualification proceedings. If the disqualification petitions are adjudicated based on the decision of the ECI in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shivsena claiming to be the real Shivsena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)(b) as well. When there are two whips appointed by two or more factions of the political party, the Speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the Speaker on whether a member must be disqualified under paragraph 2(1)(b) would also depend on the decision of the Speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a